Will contests. A will contest occurs when someone challenges a will and asks that it be thrown out as invalid. Although they are relatively rare, will contests do occur, but they can only be brought by a person with standing. That means someone with something to gain, such as inheriting a larger share of the deceased's estate or having a greater voice in the management of the estate's property, if the will were to be found invalid. If the will is found invalid, it won't be admitted to probate. A will contest can be brought by someone who would have inherited as a matter of law if there was never any will. For example, if the deceased's sole survivors are a son and a daughter, and the will leaves 90% of the estate to the daughter and only 10% to the son has standing to contest the will, because if the will is found invalid, he'd be entitled to a 50% share. A will contest can also be brought by someone who would get more under an earlier will than he or she receives under the later will. For example, let's assume in the deceased's 1995 will, he wrote in a bequest of $100,000 to a Chicago charity. Several years later, he moved to Arizona. And in 2010, he wrote a new will, leaving nothing to that charity. The charity would have standing to challenge the 2010 will because it would benefit if the earlier will was effective and the later will is not. Now, you just can't challenge a will and start a will contest without some legal basis. The most common reasons to challenge a will are: the will may not have been properly signed and witnessed as required by the state's laws. Most states require the signature be witnessed by at least 2 or 3 people who have nothing to gain under the will. Another common reason for challenging a will is that the deceased lacked what the courts refer to as testamentary capacity. This means that the person who made the will was either too young or mentally ill or otherwise incapable of understanding the process or implications of writing a will and designated who should receive their property on death. A will also may be invalidated when the process of creating the document involved fraud, force, or what is sometimes called undue influence. For example, if it can be proven that an elderly, very sick, or otherwise vulnerable person was essentially tricked or bullied into making the will, it could be found invalid and thus not admitted to probate. Will contests may be rare, but they involve a significant amount of legal work and almost always require the services of a very experienced lawyer. Having an experienced lawyer prepare your will and supervise its execution and witnessing is one good way to minimize the potential for a will contest down the road. There's lots more information on this and 100 other legal topics on FreeAdvice.com, with additional videos, easy-to-understand lawyer-prepared articles and FAQs, the Free Advice forums, and the Ask a Lawyer service. Looking for an attorney? AttorneyPages.com is the place to start.